Oops. All right. Good morning, everyone. Happy rainy Tuesday. It is not the nicest here in Indianapolis, but I'm Diana Dorr. I am the certification director and legal consultant here at the Indiana State Library, coming to you from the Indiana State Library, where Indianapolis is very moist today. So hopefully your weather is not, because it's gross. Today's webinar will be on public records requests and what is and is not a valid request. And we're also going to discuss retention schedules for documents that need to be kept. So I would also like to thank Sylvia Watson, who's my boss, our general counsel, who is watching the chat and will monitor and answer your questions if possible, and then bring them to my attention when we get some pauses or if they need to come up immediately for me to answer. And then Lisa Meadows from our MLS division is helping with the recording of the Zoom. As a note, if you have sound issues, they are probably not a global problem, so please don't put them in the chat. And you might have connectivity issues. If we do have a true global issue, Lisa will say something about it. But always remember, if yours cuts out, we are recording this, as you heard at the start, and it will be posted on our YouTube after everything's all good to go. So about at least a week later is when we normally ask. So without further ado, with a little background too on this, the reason we chose this is I'm not quite sure if other libraries have had an issue with it, but here at the State Library, public records requests became kind of a little problem for me during the lead up into getting the gold stars on everyone's driver's licenses, because we had a lot of requests for people's getting something very specific coming in and we had to deny them. And I think it kind of brought to light that people don't quite know what is and is not a public records request. So we decided to do it on this to help other libraries who might be encountering similar issues, or just so we know in general. So today we're going to go, what is a public records request or a public record according to law? What is a library records versus a business record? Because libraries have very specific things that we keep that don't really need to be distributed. Who can have access to these records? How do you validate requests? I'm going to show kind of some examples of what denials look like. Retention, and then we're going to go over retention schedules and all these things. I will say a lot of my information has come from the public access counselor here at the state. And so he has a lot of, I believe it's still he, has all these materials that also discuss open door policies, which that's more Sylvia's genre for trustee meetings and all those rules. And so if you need these, I have some links in there and I'll send them back out at the end also. And the same with the retention schedules, that comes from the Archives and Records Administration. And that is where I got those, and those links will also be included. All right, so we call this APRA, which stands for the Access to Public Records Act. So APRA is codified in Indiana Code Section 15, subsection 14, and then 1.5. It was originally passed by the Indiana General Assembly in 1983 and most recently amended in 2016. And it was enacted to permit the citizens of Indiana broad and easy access to public records. A lot of this, if you want some history on this, of course, if you think back to the 1960s and 70s, Pentagon Papers, we have a lot of secrecy going on in government. People were not happy about it. We also have some tensions going on with the USSR, who is definitely not giving anything to their people. So there became a cry in the 70s and 80s by the American public, both to the federal government and state governments, to have more accountability to where your money is being spent and what's going on, so there's no shady dealings and stuff. So that's kind of how APRA historically kind of came about. These give the public a chance to review and view public records in order to understand what is going on in their government, as I've said. Now, a lot of this is already public knowledge and it's already out there, but some things, of course, aren't. And we are trying to just make it transparent so people trust in their government. Okay, who can access these records? Any person. A person includes an individual as well as a corporation, limited liability companies or LLCs, partnerships, associations, and governmental entities. So essentially anything that is a sentient being and is not an animal. So if you have opposable thumbs, not a raccoon, you can access these records. A non-resident of a state or town can access these records. So I'm originally not from Indiana. So if I thought something shady was going on in my hometown from gossip I was hearing, I could contact my local county and see if I could get these records if they fit the requirements and understand what's going on in my hometown for purposes of my dad still lives there. You will see APRA requests most commonly used and discussed for use by media in an attempt to do a story for things that they cannot access. You will see these for bigger people, the governor's office, lieutenant governor's office, treasurer, all of the groups like that, they will have the most public records requests because they might have more stuff that is able to be hidden, and also their stuff is more newsworthy than a public libraries may be considered. So anyone can access these. So any library patron, if you want to think of that, or any citizen in it, a student, a kid could access it if they really wanted to, if they're trying to do something for school, if they needed the records or they were interested, you can do that. And they do not have to be a citizen of that place. Okay, the next thing is what type of documents can be accessed. To be required to be accessible, a document must be a public record from a public agency, and public libraries do get included in that. A public record is defined as any writing, paper, report, study, map, photograph, book, card, tape recording, or other material that is created, received, retained, maintained, or filed by or with a public agency and which is generated on paper, paper substitutes, photographic media, chemically based media, magnetic or machine readable media, electronically stored, or any other material regardless of form of characteristic. So it is a very big catch-all. Pretty much anything counts as this. Electronic records count as this. It's counting like microfilm. It's counting types that we don't really use anymore. The chemically based media kind of makes me laugh because that very much gets to like the old photographs and silver plates when I think of stuff like that. The full list, and this is also in Indiana Code statute, which I have right there. So the question then be, if this sounds like it's anything, what can be excluded from this? And there are things that can be specifically excluded because this is just the type of material and physical documents or electronic documents that can be requested. Okay. Sorry, I apparently skipped a slide. So we will in a second get to what can be denied or redacted or one of those things and not quite excluded because there is some things that can be fully excluded. The next part is you have a certain time frame to respond once a request is put in. So if a requester is physically present, someone can walk up to your library and make a request for it verbally. They can do it by telephone. They can do it any of these ways. You have 24 hours to respond to this request. Now, the 24 hours, and I'm going to have this again, is in business hours. So if you have it as a digital form like the Indiana State Library does, I sometimes will get them at 7 p.m. on a Saturday. They'll come into my inbox. My 24 hours does not start at 7 p.m. on Saturday. It starts 8 a.m. on Monday. When I log in, then I have 24 hours to respond to their request and either accept it or deny it. So you have 24 hours to do that. If the request is made by mail or something similar like fax, something that takes long, well, not fax, faxes are pretty fast. You have 7 days from the date they received the request to respond. Try to answer it as fast as possible just because you need to get back to these people. Production of documents is not required within that 24-hour period, but within a reasonable time. So for these, when I get my request in, if I show up on Monday, I have one sitting in my inbox. I have 24 hours to review their request, accept or deny it, and have it and get an email back to them to let them know. But I do not, if it is a valid request and the records need to be requested, I do not have to give them those records in 24 hours. I have a bigger time frame to get that because sometimes it's going to take longer. You have to respond to the request to the state if it is a valid request in the above timeframes, but you do not have to find the records. So sometimes they might be in archives, they might be in odd spots. you might be digging through some things, you have more time to go through these records. So the reasonable time for fully responding and giving documents is kind of odd. Like, what is reasonable? Legal terms really love the term reasonable, and reasonable is incredibly vague and broad, so it doesn't mean it. So you can take a bit longer to get back to them in order to fully respond to the request, because you want to fully answer their request within reason. So if their records are in a different building, like right now, if you did not know, the Archives and Records Administration here in Indiana is scattered throughout multiple buildings. If they had to pull stuff from other things, you have to give them more time. Could your stuff be in storage boxes? Could your stuff have been moved because of a natural disaster, or you moved, or a cleaning thing? You can have some time to dig through and find them. Some of the items may need to be redacted. How much of these things do you have to edit out? Because they are either confidential information or personal identifying information or other items. Also, if it's a busy time at the agency, like right around now for a lot of people, it is the end of a fiscal year. If you get requests and now you might be able to justify taking a little bit longer. I would still try to get back to the person fairly quickly, but if it is going to take longer because you're a one-person show, just let them know and keep that communication line open. That's what you want, is to say, I understand your request. I'm going to get there. I've got to finish these like legally required deadline things, and then I will get to it as soon as possible. Don't take so long that it becomes a problem and they can file a complaint, because they can file complaints, but use a reasonable time. If it is the end of a fiscal year, as I said, just again, let them know you have mandatory deadlines, you have things that have to be done, and keep that communication open. Say, we're not hiding anything from you. We just are trying to get these. We're very busy right now. We're understaffed right now. Right now, I know a lot of people, it's also the start of summer reading, and that makes you very crazy and busy. Fun, but it can make it backlogged because staff is being pulled in other ways. So now we're kind of getting to those things that can be excluded and denied. There is a full statute that provides the procedure for denying a request for APRA. If a request is made orally, you may deny the request orally. I would still recommend keeping a paper trail and following up with an email or a document saying, hey, we received your request. This was what you said in your request. This is why it is not a valid request, and we are not going to fulfill this request. Don't do those. Like, we can't do this. Just keep a paper trail so they don't come back and say, well, I never got told, or you don't want it to be a he said, she said. Paper trails. That's the lawyer in me is going to say, leave a paper trail. If a request is made in writing, the agency may deny the request. If the denial is in writing, the denial has to include a specific exemption authorizing the withholding of all or part of the record and the name and the title of the position personal responsible for the denial. Right now, ISL has a newer, I think it's been in the past, it's been out for less than a year maybe. We have an online portal where we can do everything through, and it's automatic, and the whole state is eventually switching to this system. ISL was just one of the first ones. And when Sylvia and I are the main people who deny it or respond to these requests, and our name does get attached to it, and we state why it's reason and all these other things, and like a whole sentence. And I'll show you an example of what our response back to people for a denial looks like. So they can know, and they can contact us if they need to, or they have another way to do it, say, well, why, or need more explanation. There are things that you do not have to disclose because it is confidential. This is things that you could potentially have to disclose, but redact, or could fully not disclose, and you could deny it for that. These are confidential by state statute or federal statute, and there's the Indiana code for it. For libraries specifically, I'm going to note this, and I'll talk about this again later also. Indiana does not have a statute that bars requesting of library borrowing records from a patron. So you could get a request for that, but you may be able to say it's confidential. You do have to have a library policy about it if you don't want to disclose it. But even then, you could get trumped if like a search warrant came in for it. You could have to disclose this information, or if it's police or not just a public resident of that. If it's a kid, definitely going to have some issues there. But again, Indiana doesn't have a statute. States like Michigan and Iowa do actually have a statute that protects patron records from being requested. And those are confidential, but Indiana currently does not have that. If your social security numbers are contained in public records, those should not be disclosed in the slightest. Anything else that also has personally identifiable information could be considered confidential, needs to be redacted. Driver's license numbers. Indiana has a very broad statute about privacy and data information and what needs to be protected, and that would need to be either not disclosed at all or totally redacted from it to protect people. Libraries shouldn't really have credit card numbers on file, but things like credit card numbers, driver's license numbers, social security numbers, even birth dates, stuff like that should be anything that could help figure out where people are. Addresses should not be disclosed. If you are a patient medical record, I don't know why a library would have those, but you could have historical records, doubt it, but you do not disclose patient records unless you give written consent. Of course, that's a HIPAA issue, but keep in mind HIPAA only does apply to the doctors if those records are in a different doctors, nurses, the hospital system. If others have those, you can. And if the patient says, I am willing to disclose it for medical treatment purposes or scientific purposes, it can be disclosed. But if not, no. Trade secret information. If you know the secret recipe to cane sauce or the breading on the 7 herbs and spices KFC, that does not need to be disclosed if someone asks for it. Of course, those are private entities and not public, but if it's trade secrets, it gets to stay on the down low. Certain foreclosure information. And then this one actually does happen. Grade transcripts and license exam scores and licensure processes. So I handle certification here in Indiana for librarians. If we had a exam line or like a test, which we actually have had in the past, I would not have to disclose those. Those can stay private if it was for the purpose of it. We kind of ran into this problem because this was last summer. I was actually cleaning out filing cabinets, trying to make some space for more certifications that were coming in. And I found a bunch of old ones, and they were from some of them from the 90s, the early 2000s. And we had to look at retention records, which we'll talk about later. And then how do I properly dispose of these? I think we didn't quite figure out what to do, and I think they're still sitting in a different filing cabinet. But we did actually kind of come into that problem. And we've had people try to request parts of things, and we have to say, no, you don't get to have those. Also, yeah, if you went to a public university and someone wants to get your transcript, no, you have to request it for them. There are things that you discretionarily can turn over at your choice. Records that are intra-agency or inter-agency advisory or deliberative material. So you're figuring it out, you're trying to make a new policy, including material developed by a private contractor under contract with a public agency that are expressions of opinion or a speculative nature and that are communicated for the purpose of decision-making. So if your library is in discussions with a contractor to fix your HVAC system or update the carpet in your library, but it is not the official, the contract's not signed, you are still just deliberating it, that technically you would not have to disclose. If it's not final, you do not need to share it, but drafts of these records are disclosable per the public access calendar or counselor, and they can be watermarked them as a draft. So you could have to disclose them if someone asked for these materials, but they would just be marked as draft and not final. And then you would have to, of course, show the final stuff later too. This one gets important. Personnel files of public employees and files of applicants for public employment are discretionary. However, if someone asks, did so-and-so work for you and then they want the dates that they worked, you do need to turn that in. If someone asks a public employee how much they get paid, if someone wants to know how much I get paid, you have to turn that over. The business telephone number, but things like the private person's address, The other very specific information that does not need to be disclosed, that is personal information, should not be, but records of, did this person work there? How much did they make? What's the business telephone? What address did they work at? That does need to be disclosed because that is public information that is up. We've kind of seen some issues with that. I will say I have certification, I have some information on people. And we have actually had a request come in the past 5 years or so for someone wanting an address of a person who was certified. And we looked at it, and it did come in as public records request, and it was denied because it is personal information. We did tell them they were certified, for how long, they could look up for how long, but that's already on a portal, so they could already access that information. But it was that more personal information of the person's home address is what they were looking for, and that was denied because that is private information. Law enforcement investigations and attorney documents are also discretionary. Attorney documents, if someone's asking for them, that's super murky and can be very difficult because there's a lot of layers for that, including attorney-client privilege, work product doctrine, lots of very legal things that lawyers get drilled into their heads. And attorneys are probably not going to turn things over because they don't like to turn things over. And law enforcement, investigations, also, if it's not in the public record as a trial or a public court document, probably not going to be turned over. But it can. There have been cases of it where people's names have even gotten out for very private, very awful cases. Not a great time. Those make it to law school. You get to learn all about those. Not a fun time. You can get requests for email. Oh my gosh, I have a blank slide in here. A public record is any record, including electronic media, that is created, received, retained, maintained, or filed with a public agency. Electronic mail must be available for inspection and copying by the government body unless an exception to disclosure based on kind of the exceptions we talked about or the content of the email applies. Email must be maintained in accordance with records retention schedules, which we'll get to at the end of this. But yeah, you do possibly have to turn over emails unless they are subject to not being disclosed or those discretionary things, or they can also still be redacted for parts of it. And even though I deleted this next slide, it's going to show up blank. Thanks, internet. What the public thinks APRA is versus reality. A lot of patrons will think that a public agency has to answer my questions under APRA. That is incorrect. Yes, but also within reason, they don't have to turn everything over, especially, sensitive information. Yeah, don't do that. A public agency has to keep records forever, so it's not appropriate to respond to that when the record no longer exists. Now, when we're going to talk with retention schedules later of, you don't always have to keep things forever because that is just too much. That's just thinking of even how many files we have here in my one office in the state library area of how much we are required to keep. If we had to keep everything, it would be an insane amount. A public agency must handle public records requests before handling other matters of the public agency. Again, that's incorrect. They have other things. Certain larger state agencies and other groups will frequently have a public access person who just handles public records requests. I know for a long time, the Family and Social Services Administration for the state, or FSSA, actually had a whole attorney whose whole job was public records requests. That is all they did. But that is a very large agency that handles a lot of very, very taxpayer forward things, Medicaid, Medicare, mental health, all of that falls under FSSA. So that was their full-time job, was how they got paid, and that was an attorney. And I actually knew them for a while, but I don't think they're there anymore. People also think a public agency must keep records in a format that's most convenient for me. That answer is no. We keep them what is business records or the requirements or what is the standard for your group or your library. They may not be the most convenient for the person. A patron may request them they want them faxed to them, or they want them a different way. That's not how this rolls. You can give them to them how works for you guys, but you do have to provide them with the materials they requested. It doesn't have to be original because you have to redact it. It can be like a copy, but it has to have the items that they want on it. Okay. The next part, what is the library record versus a business record? Because libraries have a ton of information, as we all know. So a library record is a document that is already accessible in another way to the public for public to access and does not pertain to the running or the choices of the library. This one is what I was dealing with during a lot of times, and we get it here at the State Library. We get requests for marriage certificates from the 1890s or even more recently. Those can be accessed through the genealogy or through reference, and they are not a valid APRA request. You can access them a different way. Yes, this is one I actually got earlier this year. That did get denied, and me going, hey, please contact our genealogy division. They will be more than happy to help you with this. My other example is a catalog of all the books held in the library collection. If you happen to have a whole Excel, I would think it'd be an Excel sheet for your every book held in your library, and someone wants a list of it, that's kind of one of those discretionary things of if you have it as an Excel, you could give that to them, or but you do not have to make a new sheet for them. If they can go through your catalog already digitally, which I think all libraries are at this point, then you do not need to do it. You could direct them to look through your online catalog. If they're not a patron of your library and yours is maybe behind a paywall or you have to log in, you can help them through a different way for that, but you don't need to make a whole Excel sheet or list of every single book in your collection. That is too much to do because there's probably thousands, if not millions, of books in your collections. Business records for the library are records that pertain to the administration and running of the library. These would include funding documents, contracts, purchase orders, emails about topics. A lot of things like contracts are already going to be posted on portals. You already need to have those up for transparency. How you get your funding, grant approval documents, grant documents, those can be totally requested. Purchase orders, emails about purchasing stuff and purchasing decisions, that can be maybe a little, if it's not pertaining just to the straight topic they want, you could get a little iffy there. Emails can be restricted, or you don't have to divulge them if they're not part of something that actually pertains to the public. Parts of employee records, as I've discussed, do not need to be turned over, but when they worked there, things like if you knew they were certified for Indiana, how much they made, those items, those specific parts would have to be turned over. All your trustee meeting minutes already should be posted and already online, but those can be requested and accessed to be reviewed. Statistics, such as how many books are checked out and used, that gets a little iffy because I could see you being like, we don't keep statistics of these, or it's going to be a really big burden to do so. You could then come back to the patron if they wanted every single statistic of a library in a year. You could narrow it down to a month. You can narrow it down to like just children's books or just adult books or specific like smaller sections, because that is such a huge thing that you could definitely approve but deny it at the same time. You could just say, here are our top books most checked out or requested, or book patrons request us to purchase, or even, video games, if you have those, books, or not books, movies, magazines, all those other lists. Just narrow it down to smaller sections, because giving a huge statistic of every book checked out in a year, to me, is just insane and overburdensome. Catalog lists, if you don't already have it public, which most of you do in a digital system, and your policies, which you should already have public and should already be on your website. And I know not, because I sometimes have to go hunting for different libraries. This is my little reminder that your library should or your policies for your library should always be posted on your website. and posted in your library someplace physically, because if you don't, how are people supposed to follow them? And then if someone gets a public records request and you have to turn it over just the first time they find it, that could be a problem. So post your policies online. Friendly reminder there. Again, as I said earlier, patron records specific or checkouts could be honored unless a policy exists to protect them. This is, again, where I'm going to go to the policies. If your library does not have a policy to protect patron records of, we won't turn over children's records or specific people, or we won't, then there's nothing to protect you in the Indiana Code. We don't have a state law to protect these records from requests or being told to hand over. It's a very interesting time where people are requesting things from people and libraries are under scrutiny. So if you don't want to have to turn over it, you do need to have a specific policy. This also can be a problem. I could see, I'm also a former teacher. If people have not come to a webinar of mine where I've mentioned this before, I could see it if you don't have a policy and you have a parent requesting a child's, you don't know if that parent, even if they say they're the child's parent, they can prove it, is allowed to have contact with the child, because we don't keep records of that. We are not a school where we have access to that. So even if they say, well, this is my child, you don't know if there's a no contact order. You don't know if the parent does not allow physical custody, if there's a restraining order. You don't know if there's any of these things. So it's very difficult to then try to say, I can't, or I can hand this to you, and then it could cause other issues or items like that. So I would see there's some problems there. So if you haven't ever thought about having a patron record request policy, maybe think about having one of these days. All right, so I'm going to pause for just a sec. Do we have any questions yet, Sylvia? I'm not seeing anything on my end.
You've been handling them as they go, so you're good to keep going.
Sweet, thank you. All right, so the next thing is access to records and how people can request or deny these. So your library should also have a policy on how you handle these, and your staff should know it. This could be through something like a form, email, verbally, and then have rules for approving or denying requests need to be clear, and in the time frames required, which is reasonable for getting items back, and 24 hours for responding to a request. Again, this should occur during normal business hours, and if someone gets upset because they sent in a request because you have an email or they emailed you for it and they sent it Saturday, or I'm going to say Sunday for a library, but you're not open on Sunday, that timer does not start till Monday. Any person can make these requests a patron member of the public, so always know that. You can't just be like, well, you're not a patron, you can't request these. It does not matter. It could be a business wanting your records for something because they're trying to donate to you, or there could be other things, or media, or a school, or items. If request is approved, you need to give requested materials within a timely manner. And if denied, you need to state the reason why. Stating that it is not an appropriate APRA request is fine, because it's not. Do try to give them more than just like, this is not an APRA request. You need to tell them why it's not, or where it could be found, or something else. Give them more. State that the information should be found on the website, and be specific and detailed, because again, this is public. We live in the era of the internet and social media. And so if you just say, well, you can't have this, and you don't give them a real reason, you never know who's going to become, complaining about it, or sending other emails, or contacting the media, or contacting other things. So just be thorough, and kind of cover your butt. So I have a next slide is what ISL's request or denial form looks like. Again, as I mentioned, we've switched to, the state has switched to an online form. Previously, we were just, I believe, through email. We went to the form not too long after I started here. I started full-time about a year ago. So we've been on this pretty much the whole day. I never experienced an APRA request come in via email. I've seen some in older documents that I've gone through. Our form has caused a few issues because people think, again, this is where, this started, public records requests, people think it's like a reference request of like, I need help, I want this document. They don't quite know it. Unfortunately, we don't have the space on the form to say this is or isn't a public records request at the start. So it's caused a little bit. I remember when we were like creating this with the company that had contracted with the state. I think we said, oh, we get one maybe at one a year, maybe at that. And then I think immediately we got about 3 and we were just like, oh gosh, okay, so this is a different. So do know that sometimes if you have a form and it says public records request and it goes on your library, you could get more requests and they could be problematic. But this is a request that I received, I want to say in April, for a marriage license. I have redacted a bunch of the information, even though it is public, because all public records requests then get posted online afterwards when they are accepted or denied through portals for transparency. Just because this is going on other videos, I did redact the information. I had this person need their marriage license from Pulaski County, and they gave me the name, the date, all these things of both parts of the couple. And they wanted it to come from me. I knew, because this was like the 3rd or 4th one I had at this point, that this was for the driver's license to get the gold star, because you did need your marriage license for that. Here on my form, I have a point that says, is this a valid request? You can notice I said no. We have a spot where we could comment on it and say more specifically why, but we do also have down below like actual more specific of why it's being denied or approved. So if I needed clarification, like if it was too big or if it's too broad or it's just very confusingly worded, I could say I need clarification and it would send it back to the requester, because they do this with email. I can say it's not an APRA request and it closes it immediately. Records already available, closed with instructions. This becomes, Sylvia and I've had some discussions a couple times of what is the difference for us between not an APRA request and records already available. So if someone asks for a contract between us and I'm just trying to think, one of our smaller contracts here, I would say records already available, because once we do finalize contracts, it goes online in a portal, and you can already access that. And then I'd give instructions on where those are. Records are not here, that you're contacting the wrong agency. So if someone asked for Medicaid records for something, I would deny it and say, sorry, no, this is not, Indiana State Library does not hold these records. Direct to another agency, I could also do that similar, or other, which would close it. A lot of these are closing it. If I said yes, it would say, just then give tell them, yes, it's been approved and that it's going to come out within a timeline. I'll say that what I've, again, started with most of these, I do get closed as not an APRA request. Or occasionally, I think the one I had for an actual genealogical record from 1890s was records already available, but that could have also been not APRA because it's not a business record for the state library. And then you see down below that we have a kind of standard that we say, which is, this is hello, thank you for your thing, but this is not a business record for the Indiana State Library. I give the reference desk number if they want more help, but for all of the marriage license requests I was getting, we actually were telling them to go to the county clerk for the library, for the county the license was taken out in order to receive a copy, because we have unofficial copies that are not the actual ones that you need for your verified driver's license. So that was always what we said. And this is what their email looked like. That would go back to them. It's pretty much what I said. I never had anyone complain when I denied requests. They could have, because I believe my email was attached to it, and they could have gone back to that. But yeah, we had about, I want to say 5 or 6 of these marriage license requests. And interestingly, most were from the 80s and 90s, if I remember correctly. So that's what we would say. Keep it formal, keep it polite, just explain, be transparent. And then you also see that they have standardized language that says the public records law is designed to make an agency's records available for inspection rather than to answer questions or explain agency decisions. So submitted in the form of the request for records, your request instead seeks information or explanations of a decision which is not subject to APRA. So it kind of tells them why it's getting denied. And then we give our own background. Again, it's a state, your library will probably not need anything like this. But if you wanted to consider language, that would be more of a standard in case different staff members or changes or either things. Standardized language is always a good idea. All record requests, both valid and invalid, should be kept for review. They do get, all state ones get posted in the portal. A lot of the agency ones sometimes will go to individual agencies. Others will get posted to like bigger things. Places like the governor's office have their own on their website at all times for their website to see what was requested and denied, which is where you'll see a lot of the media requests. Or you just need to keep it to see that it's there. Some court cases from Indiana involving libraries I have seen, by the way, are involved due to requests being improperly denied. So just as a little heads up of like, if you just say, oh, it's not a request, be a little careful, because I saw at least every time I periodically have to search for court cases that involve libraries in Indiana, that is one of the things that pop up because people got denied and then they sued and the library unfortunately lost. So has not happened in the past, I want to say at least 10 years from what I remember, but it has happened. So, all right, I got 20 minutes and we can do validating, well, validating requests, I guess is the next. I thought it was going to be on my last thing. So is this a request for business record? If you're reviewing it, if yes, they cannot already access these records, accept and find the records. Is it a library record? This information can most likely be found elsewhere on the library's website or in a collection, and it is not a request. You can deny it. Giving the number for reference, inviting them to come visit the library is all fine. Of, yeah, if you want this, this is great. But please don't, this is an improper use of this request. Also think of like, is this not even something that the library has information for? Like, we don't have this at all. You should contact someplace else. Just like marriage certificates, we have like genealogical record copies. We don't have the official copies. So it could be denied. Just direct them to the place for requesting information. Invalid requests, this, by the way, did come direct from the public access counselor. As an example, an employee's job performance evaluation kept in his personnel file may be withheld at the agency's discretion pursuant to the code. The factual basis for an employee's termination, however, must be disclosed under subsection C. So if it's you're terminating an employee because poor performance or reduction in force, anything like that, that would have to be disclosed. But your performance evaluation, where people tell me that I need to stop talking as much as I do, would need to not be, it does not have to be disclosed. Another example, as a request is received by a county highway department for the dates of the county road 500 north has been paved between the years 95 and 97. The request wants it in a list form. If the county does not maintain such a list, it did not need to create one. The requester would, however, be entitled to access the county's documents that provide pertinent information to satisfy it. So this is where I'm getting at if you have it in a different format, you don't have to give it in a specific list or an Excel sheet if they want like all of the records of every book that you have in your library. If you have it in a different format, you can give them that format because it is too burdensome to try to give it in a different format, and you do not have to. That's a misuse of time, essentially. It has to be a reasonable alternative. It couldn't, like, if you have it in a Excel sheet and they want it as a bulleted list, you can give them the Excel sheet. It does become a little different because libraries we have quite a different set of information. Okay. Any more questions I need to answer?
No, we're good.
Thank you. All right. I'm on where I thought I was, which is record retention, which is something people don't always think about. But it is part of working for the public and working with the public is you do have to hold on to records for a certain amount of time. All of my information, again, came from the Indiana Archives and Records Administration's portals online, which I would say be careful if you just Google to look at these links. They've recently updated their website, and so some of the links you now have to like go through kind of odd ways. I have linked them in this PowerPoint, and I'll send them out again. because I ran into that issue and I don't want someone to be stuck like me. The public library's retention schedule and the county local general retention schedule were revised in the past couple of years. All public libraries in Indiana must follow the same general retention schedule. Any records not on the approved list cannot be destroyed without the permission of your county commission on public records and the IARA, or the Archives and Records Administration. And that is from the PDF of Chapter 14. I will note Indiana State Library is different because we are a state agency. So we are not on this retention schedule. This is for public libraries. So Indianapolis Public Library, Hamilton East, all the smaller, no matter what size library you are stuck on this retention schedule. Okay. A copy of a record is the copy, or in special circumstances, copies of a record that your agency has chosen to officially fulfill as records retention schedule requirements and any other state or federal rules that affect that record. A duplicate is any other version of the record that contains the same information but is not being used to fulfill the record's retention. Unless appropriate record series specifically states otherwise, duplicates are considered non-record material and may be destroyed at any time. No permission from the IARA or your county commission of public records is required. No forms will be submitted. So what this means is you can have, so say your copy gets like a tear or it's held together with tape, you can photocopy said copy and put that in your file to be held on as the original, even though the original was destroyed. But then if you just had, like, I printed off 3 of the same form, those would be duplicates and not copies, if that makes some sense. Record series listed on a retention schedule, but not designated for permanent or critical keeping. Any record may be digitized according to the policies that they have listed. And there are electronic retention guidelines. Once the electronic records have been verified for completeness and legibility, so if it's handwritten and it's scanned, you have to make sure it's still readable because sometimes it doesn't happen that way. They can be used as a copy of a record with all records retention schedule instructions applying to them, while the original version becomes a duplicate. So if you are trying to downsize the amount of paper copies you have, you can scan everything, digitize it, get it approved, and then make the original paper one go into a duplicate system. And so if you did want to destroy it later, you could. The copy of record for these records may be destroyed only after they have reached the end of their designated retention period and you have filled out a notice of destruction with their guidelines and retention schedule. After this destruction, you have to submit a copy of the completed form to the secretary of your county commission. So it is a lot of work to destroy records. And if your office would prefer to donate the records to an interested historical entity instead of destroying them, you have to submit another form to the county commission, and they must be approved. So if you have a local county historical society that wants these records for what books the library had, what events it had, you could do that. You do still have to fill out forms. So it's more paperwork. What must be preserved? Record series determined permanent or critical must be preserved permanently in the various options. And I'm going to show you, I have this screenshotted twice of the required thing. So it's not everything is required to be kept, but it is a specific list. There's only 1 page. Ours at the state libraries, 2. All information from the county library PDF from the Indiana Archives and Records Administration. So again, you have access to this. It's a 4-page document. A lot of these details I'm using actually come straight from this. So you can see here, you have to keep your annual public library report, ledgers, patron library card, or borrowing card applications, public access cards, and non-resident, non-fee interlibrary loan files, all these specific things. And then to the right, it says retention period for how long. So you only keep applications for those library cards for 3 years, and then you destroy them. Same with other ones. All your ledgers are permanent though, and your public library reports have to be destroyed after 10 years. So I'm not going to read the whole list because I'm running a little bit late on time. Permanent versus critical records. So permanent records are those of long-term or permanent historical value, like those ledgers, and must always have at least 1 copy of a record in existence in 1 or more locations, and listed below and what it meant listed below is on this chart. Critical records are those without the state, which the state of Indiana could not properly provide services or document identity and ownership of property. Critical records must always have at least 2 copies of record, preferably in 2 different locations. So one is always held in case a building catches on fire or something, or a flood or some natural disaster would happen. Formats for permanent and critical records. All the copies of a record may remain in the format of creation, whether that is hard copy or electronic, so you don't have to go back and digitize everything. Any records, whether hard or electronic, may be microfilmed according to the rules. Once the microfilm has been verified for completeness and legibility, it can be used as the copy of the record. Any records, whether hard or microfilm, may be digitized according to the policies. Once the electronic records have been verified for completeness, you can do it. So you could still microfilm them. I don't know if that's cost effective anymore, but you could, or you can digitize them. IRA's recommended best practices: the 1 copy of record should be physical either, and then either microfilm or paper, and then a digital, because digital servers do crash. So there's that. Locations for permanent and critical records. A copy of a record may be maintained permanently in the office of origin, so it could be held in the library. And a copy of record may be maintained by a trusted commercial or government record storage provider. If they're uploaded to a state or federal database, it cannot be an office's copy of record unless they have volunteered their system as an official repository and it fills standards which are there. Information typed directly into a state or federal database with no original document on the country local side does not constitute a record for the office. So you would still have to have a different version of that. Locations for permanent records. A request to transfer a copy of the record to the Indiana State Archives, of whether hard copy, microfilmed, or electronic, may be submitted if storage space or availability does not allow for safely maintaining a copy of the record elsewhere. If your building is having moisture issues, or you've recently had issues, you could request to transfer it to the Archives and Records Administration. And if they have space and they have the capability to take it, they may take it. If they don't want it, or they don't have the space, you still have to hold on to it. You have to find one of the other rules to fit it in. I think the new Archives building is ready next year. They may not take any requests, except maybe on an absolute emergency basis. And this is me speculating. Next year, while they're in the process of moving everything over, because it's already such a big deal to be moving everything into the new building. So think about it that way. Other guidelines: any record or file whose contents fall under more than 1 record series must be maintained for the longest applicable period. So if you have, I'm trying to think of not one of mine, you have a ledger, but it's also your annual report is in your ledger, and you keep it for the ledger period and not your annual report period. With the exception of specific forms or reports listed, the description of any of the record series are provided as examples, not an exclusive or exhaustive list. So if it doesn't quite fit, you got to look into it more. And then you can contact the county local records management team for the IARA. Make sure you're contacting the specific people who handle your files for state public library, for public libraries. And if you have more specific questions or kind of oddball questions that aren't answered, but most of their materials are very comprehensive and they cover almost everything you could think of. So hopefully you don't have to contact them, but just as a heads up. An important note: no record may be destroyed or transferred. If it is part of litigation, claim, negotiation, audit, public information request, administrative review, or other action involving the record is initiated or anticipated, even if the record would otherwise be eligible for destruction. It may only proceed after the end of the action and the resolution of all the issues that arise from it. So if you have something and someone's suing about it, you cannot, even if it's hit its 10-year period for an annual report, you got to keep it until the whole process is over, which can be more years. So just as a little heads up on that. This is, again, the list. So you see fee-based interlibrary loans, collected, paid out, program registration information, computer use, sign-up sheets and logs, meeting conference rooms agreements, newspaper collection, and a microfilm. That is the only things required by the state Archives Records Administration, county system, for you to have to hold on to. And yes, I did get the whole thing in one. Again, state libraries is different. So I know ours for the state library, this is harder for me to ask direct questions because I do not handle this that often. So I've made it to the end. Do we have any questions that I should answer?
Hey, Diana. So somebody asked a question. We've actually had some Indiana Archives and Records Administration's individual employees on here, so I was wondering if we're going to answer this. But somebody asked, so the copy may be microfilmed, but is no longer required to be microfilmed if it is digitized. Is that correct? I don't know if you recall that from looking at the retention schedules, or if the IRA people on here know the answer to that.
This wording on my end says may, which did come from the most recent PDF that they have put out for county records. But
Okay.
if IARA wants to say something in the comments to correct me, please do so. I'm fine with that.
Other than that, I think everything else has been covered, so we're good.
Sweet. But yes, so microfilm is a may, and it's a may also be digitized. So it appears to be an either or. Anything else?
That was it.
Cool. Awesome. Lisa, you can stop recording.